TV, including NBC, CBS, ABC, Fox, and the BBC. Josh is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, the Wall Street Journal, and the Washington Post, and other leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law, Houston. Josh is also an adjunct scholar at the Cato Institute. He has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. Josh has written more than 5 dozen law review articles that have been cited nearly 1,000 times. Josh was selected by Forbes magazine for the 30 Under 30 in Law and Policy, and he is the president of the Harlan Institute. He also founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. He blogs, yeah, he blogs at the Vola Conspiracy and tweets at Josh N. Blackman. Okay. Professor Ruben J. Garcia has been at Boyd since 2011 and is one of the founders of the Workplace Law program here. His courses include constitutional law, labor law, and employment law. He's a nationally recognized scholar. He has published 2 books, one available from the New York University Press and one from the West Academic. He has a 3rd book forthcoming next year from the University of California Press. And more than 25 of his, and he has authored more than 25 law review articles throughout his career. He has been elected to the membership of the American Law Institute and the College of Labor and Employment Lawyers. He is most proud, though, of his elevation to the National Board of the American Constitutional Society, where he has served for 6 years, and his role as the faculty advisor to the Boyd chapter of ACS. I also want to take this time to thank ACS for co-hosting this event with us, the Federalist Society, and remind everybody here that the Federalist Society and ACS take no position on particular legal or public policy issues. All of the expressions of opinion are those of the speakers themselves.
They're mine and his.
Thank you guys so much again.
Thank you. Thank you so much. It's good to be back at Boyd. I was here last year at the same time. Also, thank you to the ACS chapter, Professor Garcia. It's increasingly rare to have people disagree sitting at the same table. So I'm always happy when we can do it. I think it's a good model of professionalism. So let's start. Last term, the Supreme Court had a very big conservative record. The court overruled Roe against Wade. They got rid of the Lemon test. Then an expansive ruling on the Second Amendment and decisions in the separation of powers. How does last term compare to the term that just finished? Well, it was conservative, but not quite as much. President Biden said it's not a normal court. Maybe you agree with that. But the court is seeming to course correct a little bit. I'll give you some numbers. There's public polling on the court. And rather than looking at what people think about the court, I like to look at the number, what do people think about particular decisions of the court? It's more of a general, a more specific question. So the affirmative action decision, which we'll talk about in a few moments, 52% favored it, 32% opposed it. That's not a runaway conservative decision. The decision 303 creative, which Professor Garcia will talk about, that was opinion about whether a website designer had to make a website for a same-sex union. That had 43% support and 42% opposition. So again, more or less the same. What about the ruling on student debt, which maybe you all would have liked? Well, people said 45% favored the court, which killed the policy, and 40% opposed. So again, public opinion is there. Tracking the term as a whole, there was not a right-wing landslide, perhaps as it was the year before. Let's go a little bit deeper into the numbers. So the prior year, there were 60 decided cases, 60. How many were 6-3 right-left splits? 14. So again, 14 out of 60 were right-left splits. This past term, there were only 10 5-4 decisions, okay? But only 5 of those were solid 6-3 left and right. So again, the previous term, 14 6-3 splits. This past year, only 5. So you're seeing less of the court fracturing along those lines. That's fewer ideological splits we've seen in a long time. And there also were unanimous cases involving religious liberty, which Professor Garcia will talk about in a few moments. Okay? Let's go a little bit deeper, right? Let's look at the 5-4 cases where the court split. Did you know that Justice Thomas and Justice Gorsuch each joined the liberals in dissent once? So you have Thomas and Gorsuch voting with the court's liberals. Justices Roberts and Kavanaugh joined the liberals in majority twice. So consistently, judges are voting opposite of what you might think. Now, again, for sure, there are these big ticket cases where the court splits 5-4 or 6-3 right-left, but they're not as common, perhaps, as they were the year before. In my view, the justices are working to get things right. There are differing interpretive methods, different applications of originalism and textualism, and to be frank, they skipped chances that were given the court victories, given conservative victories on guns, sports, medication abortions, and so on. There are a lot of cases you didn't hear about that the court turned away that could have pushed the law further to the right. So who's in control? To some extent, Chief Justice Roberts remains in control. He's the presiding officer. He also assigns majority opinions. But it's still the case that Justice Kavanaugh is the so-called median justice, that is the justice in the middle. He was the majority 96% of the time. 96%. So it almost never happens that he dissents. Almost never. Usually wherever he is where the court is. Chief Justice Roberts was in the majority 95% of the time. So between Roberts and Kavanaugh, they're like two peas in a pod. They're almost always in the majority together. Who's next up? Justice Barrett, 91% in the majority. So the three of them are in the majority 91% of the time. Okay, now, let me go down the line a little bit. This is supposed to be a very conservative court, right? How often do you think Justice Alito and Thomas are in the majority? In the 90s, right? In the 80s? Not even close. Thomas was in the majority only 76% of the time. Justice Thomas is dissenting in a quarter of the cases on a supposedly 6-3 court. Alito at 80%. So you got this right. Justice Jackson is in the majority more often than Justice Thomas. Maybe you have those in your bingo cards? Did you even predict that? Okay. Let's talk about voting pairs. Roberts and Kavanaugh vote together 95% of the time. They break apart very rarely. They are cut from the same cloth. Okay. Justice Thomas agreed with Justice Jackson about 60% of the time, which is not very high, but still in more than half the cases, the court's most conservative members and the court's most liberal members are lining up. Okay. Another point to talk about is the slowness of the opinions. Now, this doesn't really matter to you. You don't read these things carefully, but we watch very closely. It took forever the court to issue opinions this year. It just dragged on, which meant June was extremely crowded. Perhaps one way of explaining this was the leak, that the justices created new security protocols to prevent information from leaking out, and this in turn helped us just sort of slow things down. This is also Justice Jackson's rookie term in the court. She spoke more than any new justice in the past 30 years, and she was the majority 84% of the time. It's actually a pretty good first term on the court. I think she definitely made her mark with the new bench. All right, I'm done with numbers. I now want to talk about 3 cases, and Professor Garcia will talk about a different 3 set of cases. Let me start with a case that you probably all know about, which is Students for Fair Admission versus Harvard, and Students for Fair Admission versus the University of North Carolina. These were cases designed to overrule Grutter versus Bollinger. Grutter, if you haven't taken common law, was a case from 2003 that upheld the use of racial preferences to pursue the interest of diversity. That is the idea, if you have a diverse student body, you will have different perspectives in the classroom, and this will increase learning outcomes, and that is a compelling interest that justifies these use of racial preferences. This was Justice O'Connor's sort of swan song. She retired not too long after this case was decided, but this was the law of the land for arguably the last 2 decades and perhaps even longer. Students for Fair Admission was designed to overrule Grutter. They did not quite succeed in that front, but Grutter is basically dead in all but name. Okay. Chief Justice Roberts wrote the majority opinion. The case split 6-3, kind of 6-2, because Justice Jackson recused in the Harvard case, but that didn't really matter because she participated in the other one. All right. What was curious, though, is that the court said that Title VI of the Civil Rights Act, which is a federal statute, is the same thing as the 14th Amendment. So if you violate the 14th Amendment as a public school, or if you violate Title VI as a private school, you're engaging in the same illegal conduct. So it's a weird holding, and it makes me wince every time I read it, that Harvard violates the 14th Amendment, right? This is John Roberts' way of saying, we're going to lump you all in together. And both public institutions and private institutions are subject to the exact same standards. They cannot use race as a determinative factor. That's the key word. They can't use race as a determinative factor. That's a quote. Rather, they must admit students on a racially non-discriminatory basis. Okay. So what does that actually mean? I'm sure you have admissions committee. We have one as well. The checkbox is gone. So if any of your friends are applying to college this, I guess now, right, this upcoming year, the common application, there's no race checkbox. In fact, when, at least at my law school, maybe yours is the same, when we get applications, we don't even see the person's race. That's only provided much later in the process. But the Chief Justice said, race can be considered in a different way. And this is where I think a lot of the policies might continue in a different name. The Chief Justice said that race, like anything else, might affect who you are as a person, might affect how you've developed. Maybe you've overcome adversity because of your race. And Robert said, in the application essay, you can write about that. You can write about your race in an application essay. But, and here's the key but, the school can't consider race because of race. They can't consider race because of what it might mean for your viewpoints, what you'll express in class. You can't consider race because it might make the student body look more diverse. The only excuse that Robert said a university could use for racial consideration is how it defines the person. In what ways a person's race help them overcome adversity? Now you may say, Josh, what's the difference? Isn't that the same thing we're doing all along, right? Because I've overcome diversity, I can contribute to the classroom discussion. And Professor Garcia will agree or disagree. But here's the rub, though. Universities have to be careful, right? If you're a university general counsel, you might hate this ruling, right? Too bad, because there's going to be litigation. And I promise you, any emails or text messages or Zoom calls where people say, well, we want to keep doing what we're doing all along, but just call it something else, that's going to come out. So I think among university GCs, general counsels, there's actually a caution to basically not maintain the status quo. We'll see what numbers look like. And I don't know the answer of what racial numbers will look like after this year. But I think there's definitely a change in the outcome of how universities consider race. All right. That's the first case I want to talk about affirmative action. We can talk more during the Q&A. The second case, I think, affects each and every one of you. Do you all have student loans, I'm guessing? Oh, God, I had them, man. I graduated 6 figures in debt. It took me a decade to pay them off. I'm glad I didn't. I was a sucker for doing it. But I paid them off as quickly as I could. That took me about 10 years. During the COVID pandemic, the Trump administration, again, this was Trump, not Biden, the Trump administration said, we're going to put a pause on collection of student loan debts. People are suffering, they're out of jobs, they're not earning income. Let's alleviate the burden. So what gave the Secretary of Education the power to pause payments? Well, there's a statute called the HEROES Act. It was enacted after 9/11, which says that during certain emergencies, which the pandemic would be an emergency, the Secretary can waive or modify certain regulations. And so the Trump Education Secretary, DeVos, said, okay, we're going to put a hold on the collection of student loan payments. We're not going to charge interest or penalties or late fees and so on, right? No one really complained too loud about that, at least that I remember. there was not any litigation that I can recall about the Trump era policy. Okay, so then we go from Trump to Biden, and eventually people thought, okay, the pandemic's coming to a close, the mask mandate's gone, the vaccine mandate, all that stuff sort of passed us, right? What about the student loans? So what the Biden administration said is, okay, not only will we pause the payments and not collect late fees, we're going to suspend certain amounts that are owed. And I won't go into the specifics, but there's a certain amount, you have to have certain qualifications, but for a certain number of people, they could have their loans, at least part of their loans, discharged. They wouldn't have to pay them. And Biden's administration relied on the same statute that Trump's administration relied on, this waive or modify statute. So I'll get to the merits in a minute. I want to talk first what's called standing, right? Maybe you've taken common law, maybe you haven't. There's a principle of federal courts that you can't just go and sue someone because you don't like it. Oh man, that's a bad policy, let me sue you. No, that doesn't work. To challenge a policy in court, you have to actually be affected by it. We say you suffer an injury, right? Some policy injures you, right? So, I applied to university, I'm denied admissions. Okay, I can sue, right? I had some adverse injury. Let me ask you a question. Who's injured when the federal government says, you don't have to pay back your loans, right? Because the government's not imposing a burden. I mean, really, they're doing the opposite. They are relieving you from a burden of having to pay X dollars in loans. So this case presented a problem for conservatives. Who on earth could challenge the policy? All these people had to pay less in student loans. How is that an injury? And trust me, Biden's people realize this, right? They say, this is going to be our freebie. We're going to give this away, and no one can stop us. Okay. There were a couple attempts. So one was a guy named Brown. It's funny, the case is called Brown versus Department of Education. Sort of the irony is not dead, right? So Mr. Brown lived in Texas, and he actually sued. And his argument was kind of creative. He said, well, I actually like this policy, right? But I'm not eligible, right? You excluded me from this policy. So therefore, the remedy is to kill the entire policy so no one gets it. You catch it, right? He said, I want this relief, but you did not include me. You excluded me from it. That was irrational. And because the policy is irrational, you must strike down the entire policy. Didn't work. So the Supreme Court said, yeah, no, that doesn't work, right? That's you can't complain about this. But there was another party that was found to have standing. MOHELA. What the hell's MOHELA? It's the Missouri Higher Education Loan Authority, if I get the acronym right. MOHELA. This is this kind of state entity that manages loans in the state of Missouri. And it's true that MOHELA charges fees and they earn a profit when they service loans, right? The loan servicing, you know about this, right? Whenever you get a loan, there's some entity that actually does the paperwork and you pay a fee. I'm sure you paid this, you don't even realize it, maybe. So if MOHELA actually brought the lawsuit, I think everyone agreed they would have standing because they lost fees, right? By discharging the debt, there would not be fees collected. But MOHELA didn't bring the lawsuit. Instead, the lawsuit was brought by the Missouri Attorney General. MOHELA was very quiet throughout this process. They wanted nothing to do with this because it would actually probably help them to have these loans off the books. They didn't want these loans. People default, right? People don't pay. Here, it's free money. Not very free, but free enough for MOHELA. So the question was, could Missouri even bring the suit on behalf of MOHELA? Or stated differently, was Missouri injured by this policy? The court here splits 6-3. This is one of the few 6-3 cases. And the Chief Justice wrote the opinion, and he wrote, well, Missouri, MOHELA, potato, right? It's part of the state, close enough, and he cited some state cases. I don't know if he's right on state law. I just don't know enough. Assuming Roberts was right in state law, this is probably, I think, correct on standing, but I'm not sure. On the merits, though, I think the court got it right. The statute here spoke about waiving or modifying, and it was in a fairly limited context. And this opinion gestures what's often called the major question doctrine, if you've heard of the major question doctrine. This didn't exist when I was in law school, but it's a big thing now. That when Congress wants something very big, they give clear instructions, right? Here, the president relied on a 20-year-old statute that was enacted in a very limited context, and you can't take this old statute and apply it to this new big disaster, right? That if Congress wants to legislate, they could. Indeed, Congress considered having a student loan cancellation bill, and those bills failed in Congress. Now, the dissent, Justice Kagan, she doesn't like the major question doctrine. Is how dare we second guess what Congress does and not do, right? We're textualists here, right? Why are we looking at congressional inaction? And look, I think she has a fair point. There's a robust debate with the major question doctrine. But as a result of this, any of your student loans will not be discharged. You're welcome. But this was probably of the decisions that affect students for the ones they hate the most. All right, almost done. The third case I want to talk about is not at all controversial. It is about civil procedure. Okay, everyone who took Civ Pro or taking it now, remember international shoe? Am I going to give you cold sweats if I say personal jurisdiction? PTSD, right? Stream of minimum context, stream of commerce, Asahi, right? I'm giving you your trauma. All right, so this third case is called Mallory versus Norfolk Southern Railway. It's a case of personal jurisdiction. I promise you, I think this is fun. Maybe you don't like it. Maybe you'll hate it. So you all remember from Civ Pro that in order to sue someone, you need to have what's called personal jurisdiction, right? That they did something in the state that will allow a state to assert jurisdiction over them. Maybe they're incorporated there, or it's their principal place of business, or maybe they have minimum contacts in the state. This is international shoe, right? Okay, that's all there. Pennsylvania has a funny law. It's been in the books for about 100 years. Pennsylvania law says that if you do business in our state, you're required to register in the state. All right, no big deal, right? But what does registration entail? Registration entails consenting to personal jurisdiction. Oh. You basically waive any personal jurisdiction defense by operating in the state. So we have a railroad, Norfolk Southern. This is a big railroad. They have train tracks across the country. So yeah, it's impossible to not have tracks in that state. They have tracks in Pennsylvania. So there was a tort that happened in Virginia, just make it easy, right? Norfolk Southern is registered and incorporated in Virginia. The tort happened in Virginia. The plaintiff was from, I'm making it a little bit easier, Virginia. So he sues, of course, in Pennsylvania. I simplify the facts a little bit, but that's the gist, right? And why? Because Philadelphia has very good trial lawyers, and they think they have a better shot at a jury verdict in Philadelphia than they would in Virginia. You guys know forum shopping is not bad. You guys meet lawyers soon, right? Forum shopping is very important. So the trial lawyer said, okay, look, we're going to get a good verdict in Philadelphia. Let's file there. So the only basis in which Philadelphia had personal jurisdiction was this statute. So then Norfolk Southern argued, okay, this statute's unconstitutional. It's a violation of due process, right? This is international truth that it forces us to defend ourselves in a jurisdiction in which we lack minimum context. This is not their place of incorporation, not the principal place of business, or not the minimum context. The tort happened in Virginia, right? So this case goes to the Supreme Court. And I got to say, this is one of the weirdest splits that you're going to find. Right, so the case split 5-4. You had Justice Gorsuch writing the majority opinion, joined by Justice Thomas, Justice Jackson, and Justice Sotomayor, and Alito in part. Let me say that again, right? Majority. You have Gorsuch, Thomas, Jackson, Sotomayor, and Alito in part. Never going to see that one again, right? Who's in dissent? You have Roberts, Barrett, Kagan, and Kavanaugh. Whoa, right? So I can explain that one in a minute. Barrett was a law professor. She taught Civ Pro. She likes international shoe. She wants that to be the case. Kagan, dean at Harvard, professor. She likes international shoe. So you have the two law professors. You have Kagan and Barrett joining Roberts and Kavanaugh, who just don't like changing things. They like keeping things the way they are. They're conservative in that way. And they have Alito at the majority with Sotomayor and Jackson. So this case like scrambles everything you think you know about law, but Civ Pro is just that. It gives you all the cold sweats. It still gives the justice a sweat. So what the court held narrowly, there were 5 votes to say that the Pennsylvania statute is constitutional. But I'm going to caveat that in a minute. Alito didn't go all the way. So the statute itself is constitutional. So as a result, states can now enact these statutes, like California, which says if you do business in California, which frankly I think everyone does, you are now subject to California courts. Congratulations. Welcome to the Sunshine State. No, it's Florida. The Golden State. Wrong one. Thank you. Welcome to the Golden State. But Alito wrote a concurrence, which is going to be litigated. And Alito said that this regime may violate the Dormant Commerce Clause. I think maybe you didn't say that in con law, but the Commerce Clause also affects how states regulate foreign commerce in other states. And Alito said, wait a minute, how on earth can Pennsylvania impose a burden on a Virginia corporation? Isn't that a violation of commerce? So Mallory is not home free, and Norfolk Southern's not out of the woods yet, but the case continues. So if you're taking CIPRO now, you will read the Mallory case. All right, I think I'm done. I apologize I went over time. I'm going to pause myself here and give it to Professor Garcia. Thank you so much.